I have chosen the topic of basic structure, and I think why this is important. The answer comes from Upendra Bakshi's very interesting article on this particular subject, where he said, when you deal with the Keshan Bharati case, you're not reading a report dealing with a few constitutional provisions. What you are reading is the new Constitution of India. So, Keshan Bharati is important because it is in fact the new Constitution of India. I'll elaborate upon it. And all the principles of constitutional interpretation and fundamental aspects of constitutionalism are present in it. And therefore, it is very educative, where fundamental principles of law are involved and fundamental principles go to basic structure. That said, in the same article, something very funny was also said by Professor Bakshi. He said that the Keshan Bharati case will create an illiterate body of lawyers. Why? That's because the judgment is too long and therefore may never be read, and such of those who read will never understand. And there can be nothing more pernicious than the illiteracy of the literate. So, why is this important? Such of you as are here can educate themselves of the various aspects of this particular judgment to fall out of that class of illiterate lawyers which Upendra Bakshi talked of. Now, when you deal with Keshan Bharati, as a matter of course, people bring Indira Nehru Gandhi along with it, but for the wrong reasons. I say wrong reasons because I will recommend to each one of you Sirvai. Sirvai has in his both third and fourth edition, definitely in the fourth edition, talked about Indira Nehru Gandhi's case to mention various facets of that particular case which elaborate upon Keshan Bharati, which I am going to deal in a little while. And the more important aspects of it are, one, while Keshan Bharati was dealing with what the scope of amendment was in the unamended 368, Indira Nehru Gandhi dealt with the amended 368. So, and so far as relevance becomes very important. Two, unlike Keshan Bharati and the cases which preceded it, Indira Nehru Gandhi did not deal with right to property, which is a very important aspect of this particular. Three, the air of unreality, because if you read some judgment Keshan Bharati, the consequences of unlimited amending power was one of the arguments which was raised there. And some judges brushed it aside, saying that, see, the amending power was unlimited even prior to Golaknath, and nothing happened. So this is an argument of fear. An argument of fear has a fallacy because it is beyond reason. But in Indira Nehru Gandhi, what happened was 329A was introduced over a period of 3 days into the 9th schedule, over three, that is 7th, 8th and 9th, which was passed by the Lok Sabha on the 7th, Rajya Sabha on the 8th, and the states, in fact, approved it on the 9th. In 3 days, this entire exercise was done, which became subject matter of criticism of that judgment, which I will deal with it. And if you read this particular judgment in the context of Keshan Bharati, it expounds the principle of constituent power. Constituent power, which is absolutely basic to Keshan Bharati, in elaborate detail, and brings in the principle of legality. Now, what is important with this judgment is that of all the limitations which are there on amendment, what this judgment actually focuses on is the principle of legality, which is, as I said at the outset, the most fundamental aspect of principle of constitutionalism, which is the bedrock of rule of law. And this is what that particular judgment dealt with. These are aspects not usually spoken. What basically people say is, see, Keshan Bharati was unanimously affirmed, and different aspects of basic structure dealt, rule of law, democracy, equality, and all those aspects. But the worth of Indira Nehru Gandhi is not on that summary reading of Indira Nehru Gandhi. The worth of that particular judgment is in these aspects. That said, let's come back to the history. Let's start with property. How did Keshan Bharati come? Why did Keshan Bharati come? And in the context of Keshan Bharati coming, what is the worth of Keshan Bharati? As you all know, the Constituent Assembly also worked as the Parliament. So it had two capacities in it, the Constituent and the Legislative. This is at times forgotten. And in the difference in the two is the difference between the constituent power and legislative power, which was glossed over in Golaknath and was academically condemned universally post Golaknath, because Subba Rao was in splendid isolation, where this particular blurring of ordinary legislation and constitutional law is concerned. The parliament had passed reform legislation, land reform legislation, which was struck down in Kameshwar. When it was struck down in Kameshwar, it came to be challenged in Shankari Prasad. The argument which was raised in Shankari Prasad was that fundamental rights cannot be touched. Now, this argument was summarily rejected because the court, in its reasoning, brought about a distinction, the correct one, between a legislative power and a constituent power, to hold that as far as the constituent power is concerned, is independent of the constraints of 13, and therefore there is absolutely no bar in the legislature enacting that particular legislation. Now, the First Amendment had brought in 31A, 31B. We'll come to that later because that will become very relevant for the purposes of Minerva, Vaman, and Coelho. We'll come to that later. But that is First Amendment, that is the history of the First Amendment. First Amendment was followed by the Fourth. Fourth was caused by the Bela Banerjee case. The Bela Banerjee case, insofar as dealt with the question of amount, compensation, whether it should be the just equivalent of what is there, which will be part of the Keshavan Bharati reasoning too, when we deal with what the Keshavan Bharati judgment did. But the Fourth Amendment was not challenged. Fourth was followed by the 17th Amendment. The occasion of the 17th Amendment was the change in the definition of Raiyatwari. Now, the first, 4th and 17th Amendments came to be challenged in Sajjan Singh. Now, very important aspect of Sajjan Singh is also ignored, is that in Sajjan Singh, it was never disputed that as far as the restraint is concerned, the Parliament is not in any way the Parliament is free of that particular restraint. What was actually argued in Sajjan Singh was the procedure prescribed for amendment has not been followed. That was the issue. Now, this has been subject matter of criticism by Sirvai in his commentary, because what actually happens, Justice Oak, when he was here, was talking about what lawyers don't do. Now, this is important about what judges do more than what is required, because there was no occasion for Hidayatullah or Murokal to actually deal with that particular aspect of limitation on fundamental right, because that was not the subject matter of that particular judgment, the controversy. It was not the subject matter of the controversy. Anyway, because there were two dissent in that, which brought in the question of limitations, it gave an opportunity to Subba Rao to raise this particular issue in Golaknath. And in Golaknath case, again, a wafer-thin majority, 6:5, right? Keshavan Bharati was 7-6, Golaknath is 6-5, and because of the way in which this works, the wafer-thin majority, this is also subject of criticism. I'll come to a different aspect of criticism, Keshavan Bharati, particularly Justice Chandrachud's comment about his not getting time. And as far as the pointers are concerned about consensus with 4 judges not joining that's a different aspect which I'll deal with when I deal with Keshavan Bharati. But the point is, in Golaknath, what actually Justice Subba Rao said, he said, see, Parliament, it's only the procedure which is given by 368. Power is not there. Power has to be derived from the residuary entry, read to 248. Because it is so derived, it is ordinary legislation. Because it's ordinary legislation, it's law. Because it's law, it's covered by 13. And because it's covered by 13, fundamental rights are immune. As far as the other judges who dissented, there was Vanchu, there was Ramaswamy, and there was Bachava. Now, Vanchu and Ramaswamy did not, in fact, subscribe to the question of implied limitation at all. And where Bachava was concerned, Bachava said that the Republican character of the government has not been affected by this particular amendment. But because of the judgment and the fallout, and the fact that it moved away completely from Shankari Prasad and Sajjan Singh, there was a spate of amendments which came. And the spate of amendments was the 24th Amendment, which brought about changes in the 13 and 368. The 25th Amendment, which brought about changes 31, 31A. The 26th Amendment, the Privy Council, the Privy Purses. And of course, the 29th Amendment, by which the Kerala enactment came into the 9th schedule of the Constitution. Now, because of these spate of amendments, the matter came before the Supreme Court in Keshavan Bharati. And what is generally spoken by academics is, post Golaknath, the consensus was, and Professor Tripathi in one very informed article again in SCC has dealt with this particular aspect. And I will recommend to all of you that when you read Keshav Bharti, just don't go to the judgment and just don't go to the easy summary which you are getting. What you must read, there's a book on constitutionalism and basic structure, which I'll give at the end later, which has examined the judgment threadbare. Sirvai, in his own inimitable style, has actually dealt with this particular aspect in detail in his commentary. And there are very informative articles by Bakshi, by Tripathi and others, which actually go through this particular thing threadbare to educate us as to what is it that this particular judgment did. Anyway, now these 24th, 25th, 26th, 29th Amendment came to be challenged in Keshav Bharti. Now, when these judgments came to be challenged, there was a divide. And the divide was 6 judges on one side, 6 on the other, with the balance tilting in one aspect, the 24th, and 25th and 26th are different, by Justice Khanna. What is important to understand is what did these judgments say? I'll explain it in 2 different categories. One a broad category and the other a more detailed category, because it's necessary to understand what is it that this judgment actually held. Now, the broad category was that there cannot be any amendment of fundamental rights, 6 judges said, led by Chief Justice Sikri, no amendment, though there may be abridgment of fundamental rights. The other category, that is Ray, Palekar, Dwivedi, Chandrachud, etc., they said there are no limitations whatsoever on the power of amendment. There were 2 polar extremes. Now, the balance tilted because of Khanna. What is very important, you must remember, because this is again lost when we deal with it, Khanna's judgment aligns more with the 6 judges other than those led by Chief Justice Sikri. There is more similarity between Khanna's reasoning and the 6 who did not agree with Chief Justice Sikri. And what Justice Khanna did, and this has become very important, he looked at the Constitution, the very aspects which are dealt by Sikri and the others, to hold whether it was with regard to the 5th and the 6th schedule to the Constitution, whether it's regard to Article 304, that is the original 368 of the Constitution, whether it's 291 of the Government of India Act, etc. What he said was that the power is plenary. You cannot cabin or confine it. You cannot put any restrictions in it, but you cannot tinker with it to change the identity of the Constitution. And therefore, his judgment was actually on what the meaning of the word amendment is. Amendment, that is, amendment cannot possibly, when you use the word amend and bring about a change, you cannot, in the guise of making a change, alter the identity of the most fundamental document. So broadly, which is what was explained by Justice Chandrachud in Indira Nehru Gandhi. And just as an aside, it's very important, and all of you must know, there was a confusion in Indira Nehru Gandhi's case. And why am I saying this is because how complex this particular judgment is. The question was, did Justice Khanna include or exclude fundamental rights from basic structure? Justice Chandrachud, dealing with this particular aspect, said something with which Justice Khanna, who was the author of that particular judgment, disagreed. And he said, no. As far as I am concerned, I never said fundamental rights are not part of the basic structure. Why am I pointing this out? Because of the complexity of the judgment, going back to what Upendra Bakshi said, the inconsistencies in the judgment itself, the paucity of time which was there in bringing this judgment aside, and the fact that for the conclusions which followed, there was no interaction between the judges or, for that matter, interaction with the bar. Now, for something as fundamental as this, something which is going to be the Constitution of India, a thing like this happening reflects poorly on the process. Now, we all celebrate Keshav Bharti, but when we celebrate Keshav Bharti, these aspects of Keshav Bharti also have to be kept in mind, so that in the future, we don't repeat these mistakes. That said, this is actually the broad outline, 6 and Khanna tilting the balance, but Khanna aligning more with the 6 other than those 6 led by Chief Justice Sikri. Now, what did the six led by Chief Justice Sikri say? Now, as far as Chief Justice Sikri said, the Chief Justice Sikri referred to the structure 368. He referred to the proviso 368. He talked about the institutional design, and he said that the limitations are inherent in the manner in which it is devised. He did not deal very well with the concept of constituent law, because he did not put much emphasis on the meaning of 13.2, which is the flaw in Justice Sikri's judgment. But in any case, keeping that principle institutional design in mind, he read certain limitations on the amending power. Now, as far as Shillett and Grover are concerned, Shillett and Grover made a distinction between a constituent assembly and a legislative body, and pointed out that even as a body amending the constitution, the body was acting under the constitution, and therefore by its nature was different from a constituent body. And because by its nature different from a constituent body, it necessarily had to comply with the constitutional mandate. And because it had to apply with the constitutional mandate, by the very nature of its body, it was subject to certain limitations. And in addition, talked about the consequences. Now, consequences, what you will find, the question of consequences is very common across judgments in Keshan Bharati, the consequence of unlimited amending power and the fear that the same is going to be abused. Now, that was met by the other judges by saying that as far as discretion is concerned, as far as the entitlement to exercise power is concerned, as you go higher, the checks become less. And just like the High Court can supervise a trial judge, but the High Court judge himself will not be subject to similar scrutiny, and the Supreme Court judge is not subject to scrutiny at all, because who is going to scrutinize the Supreme Court? So, because you have this unlimited power, does it necessarily mean you're going to abuse it? It's not necessary, because there can be certain checks inherent in the person and in the institution, which is a different aspect altogether. Because when we deal with independence of judiciary, we deal with independence of judiciary in the individual level, that is the judge concerned, and the institutional level, which is provided for in our constitution, where it deals with the Consolidated Fund of India, it deals with the tenure, etc. That was simply an aside from what I was saying. So, Sikri, Shillett, Grover, now Hegde and Mukherjee said more or less the same thing and talked about the difference between the core principles and something which is allied to the core principles, that basically repeated the question of limitations on the constituent part. And Justice Reddy also dealt with that particular aspect in some detail. We'll deal with that in a while, but not strictly speaking relevant. On the other side were Ray, Palekar, Chandrachud, Dwivedi. What is very important is, and this is also subject to some criticism here, and Professor Tripathi, while dealing with this particular criticism, said that this is a flaw in the reasoning of the lawyers defending the amendments, because in making the concession that the constitution cannot be abrogated as such, because this was a concession which was made. A concession was made that the constitution cannot be abrogated. Now, if you concede that the constitution can be abrogated, you cannot simultaneously say that the power is unlimited and the power is with the constituent body, because the power is unlimited with the constituent body, the constitution can be abrogated also. But implicitly they are saying that the constitution cannot be abrogated is that there are certain limitation on the power. This is one of the criticism which is of the argument for those who advocate unlimited amending power. Now, as far as the other 6 judges are concerned, what they held was that the question of restraints is alien, the terminology is clear, the power is not in any way less plenary, and the fear of consequences cannot inhibit the interpretation. Broadly, this was what said. And as far as the basic structure was concerned, they basically said that this is not something which is concrete or easily identifiable, and you cannot draw it from the preamble, because they are moral concepts. Because they are moral concepts and the preamble itself can be amended, what has to be the content will depend upon the future generations. And the future generations should be allowed the power to modify the constitution as they feel fit. And that is the reason why the power to amend has been made as plenary, as it is, so as to adapt to the times. And what is being touted as limitations are not limitations at all, because the content will vary according to the circumstances which prevail at the time the amendment is sought. Broadly, this is what broadly it was held by. Then came Justice Khanna. Now, what Justice Khanna did was he accepted that there are no limitations, as I said. He also said that as far as property is concerned, it is not a fundamental right. He approved and followed Ryan's case. What was Ryan's case? Ryan's case was the Irish Constitution, 50, the amendment of the amending part, whether the deletion of the word referendum was altering the essence of that particular provision, because the word referendum having been omitted, that provision contemplating that first in 8 years they have the power to amend, thereafter it has to be a referendum, which was altered to 16 to be free of the requirement of referendum too. But it was held at a ratio of 2:1, that as far as the entitlement is concerned, the entitlement was not in any way restricted by this particular limitation, which in fact would have covered the situation completely, and was in fact applied by Justice Khanna when he approved his when he propounded his argument of unlimited amending power. While on the question of Ryan, what is important is what Justice Sikri, because when Justice Sikri was confronted with this argument, he said something very strange, because it was something which he had to meet. He said, see, that is an Irish constitution given by God. That is what the constitution said. And because it's given by God, therefore, as far as that is concerned, the principles may be relevant for the determination then made. As far as our constitution is concerned, our constitution is not so given, not knowing that the reasoning itself was self-defeating. Because by the very reason given by Justice Sikri, the argument, the conclusion had to be very different. But that's not strictly speaking relevant. So what Justice Khanna said was, Justice Khanna dealt with Ryan's judgment. He talked about the absence of limitations. He dealt with one of the arguments was made regarding the 5th and the 6th schedule to the Constitution. Because the 5th and 6th schedule to the Constitution have certain clauses which talked about amendment and talked about amendment by reason of variation or repeal also, which was subsequently included in 368. And it was argued by Mr. Sirvai that if you look at the schedules 5 and 6 of the Constitution, if you look at those particular schedules, then you look at the word amendment. When you see the word amendment, obviously variation or repeal, etc., would be deemed to be part of it. That is the understanding. Because the argument was in Keshav Bharti, you cannot enlarge a limited amending power. That was broadly the argument in Keshav Bharti. And therefore, Keshav Bharti examined what was the position prior to the 24th Amendment. And while dealing with the position prior to the 24th Amendment, the 6 judges led by Chief Justice Sikri said that the power was limited. And the power was limited because they looked at the various provisions of the Constitution and said that unlimited amending power was absent. Now, dealing with the very argument, Justice Khanna, along with the other 6 judges, disagreed. And for the very reasons I pointed out, said that, see, the power was never limited. The power always extended to amendment by way of variation, repeal, etc. also. And far from saying that there were any limitations on this particular exercise, it was free of any such restriction. Justice Khanna, however, agreed with or aligned with the majority to the extent he said that though the power is plenary, you cannot alter what he said was the basic structure of the Constitution. Now, because Justice Khanna talked about the basic structure and said that the basic structure cannot be altered, Justice Khanna agreed with 6 that as the limitations are not there, and disagreed with the 6 who said that you cannot amend the fundamental rights. The law became that as far as the power is concerned, the power is broad enough to in fact reach to any provision of the Constitution, subject, however, to the basic structure not being altered. This was what was dealt with in Kesharan Bharti. Now, Kesharan Bharti was followed by, as I said, Indira Nehru Gandhi. And what is important about Indira Nehru Gandhi's judgment, as I said at the outset, was that unlike in Kesharan Bharti, which dealt with what was the situation prior to 24th Amendment, to reach the conclusion whether in the guise of a limited amending power, you enlarge that amending power, with the schism between the judges came. In the Supreme Court, in Indira Nehru Gandhi dealt with 368 as amended, and that judgment is important because it dealt in some detail with the meaning of what a constituent power is. And what is extremely important about the judgment is, it introduced the principle of legality. That is restraint. And in some way put the brakes on the exercise of despotic power. And why I say so, as I had pointed at the beginning, the occasion was 329A. The occasion was the hurried introduction of this particular clause. The occasion therefore was whether the power which was conferred by 329A falls foul of the limitation 368 and Kesharan Bharti. What the court held in Indira Nehru Gandhi was that they cannot be legislative judgment, because the occasion was, as you all know, Indira Gandhi's election was challenged because the matter was pending the Supreme Court. Came 329A. 329A brought in 4 and 5. What 4 said was that whatever is the law will cease to apply, whatever judgment is there will not be applicable, and if there is any appeal which is pending, the appeal will be decided by what is in 329A4. So, what the amendment did in fact was, by means of a legislative judgment, concluded an election dispute. And because by means of a legislative judgment it concluded an election dispute, the question arose, is it correct? And all judgments are unanimous in this aspect, including Justice Ray, Chief Justice Ray. And what the judgment says, it's important for you to read Matthews, because he has dealt with Bill of Attainder and dealt in detail with the question of legislative judgment. It is important for you to deal with Ray, because he said that where is the principle of law? There is a void in the name of law, and there is no principle which is to be applied. Justice Chandrachud brought in the question apart from this particular aspect, the principle of equality, and Justice Khanna talked about the democratic principle, which is. But which is most important here is the argument which was made in Indira Nehru Gandhi against something which is not spoken much. Kesharan Bharti was a limitation amending power. The limitation amending power, 6 judges said that the possibility of abuse is remote, not likely. That scenario became real because of this particular amendment. And so the government of the day wanted to get rid of Kesharan Bharti. So a very alarming argument was taken. And the alarming argument was that, see, constituent power is an amalgam of all powers, whether it is executive, legislative, judicial. You cannot demarcate. Because you cannot demarcate, the demarcation comes subsequently. When a law has been made and the authority has been apportioned. But in its constituent capacity, there is no division. And because this is constituent capacity, hence legislative judgment is permissible, and therefore 329A is valid. This was the argument of the Solicitor General and Mr. Sen in this particular case. This was actually the argument which was made. Now Justice Baig, along with the others, and of course Justice Matthews, have in fact dealt with this in detail and said, and all, in fact, Justice Baig, Justice Khanna, and Justice Chandrachud said that we are no longer in the age of Farbans. No question of there being in a system governed by constitutional law an oriental despot. I don't like the term oriental despot. This is all the West which is divided. There are despots also there. But nevertheless, this is the word which is used. And it is not an article of democratic faith that what a ruler wills should be the law. Here lies the worth of Indira Nehru Gandhi and the fact that no amendment of the constitution can ever prevail, Kesavan Bharti having been affirmed, where there is no principle or legal justification for introducing it, and the measure itself falls foul of the inviolable principles under which we exist. And what are those principles? Some of them were at play over here. Separation of powers. There is a separation of powers. This argument that, see, as far as constituent power is concerned, constituent powers are amalgam. Once an amalgam, there is no occasion of division, was roundly rejected. So what happens out of that? You accept that there is separation of powers. You accept also the supremacy of certain values. You accept the worth of democracy. Now, when you deal with the worth of democracy, it's not simply elections. It is the purity of elections. It is the contest regarding elections which actually come. And as far as that issue is concerned, that squarely rests to the court. So, judicial review, which is implicit in Kesavan Bharti, gets actually reaffirmed in Indira Nehru Gandhi. It gets reaffirmed with a fair amount of substance in each of the opinions, which places it in the center of this particular controversy. For the purposes of saving for scrutiny by the court any measure which is falling foul of that which is accepted as legally correct. This, in my opinion, is the single biggest measure of worth of this particular judgment, because it limited according to a principle which is, in my opinion, transcendent, not in the sense of 21, the overarching principle, the principle of legality, and placed it in the center of this particular discussion. That is where the worth of this particular judgment lies, apart from the incidental issues which are dealt with in the judgment. Now, Kesavan Bharti was followed by in Minerva and Aman. Why are those important? Two reasons they are important. It says the 368, 4 and 5. Now, 368, 4 and 5 was meant to, in some way, overcome Kesavan Bharti and limit the applicability of Kesavan Bharti to constitutional amendments. This was the 55th section of the 42nd Amendment. The court struck it down, and Justice Chandrachud said that you cannot, in the guise of exercise of limited amending power, enlarge the amending power itself. That is one aspect of it. The other aspect was, and this is a very important aspect too, the harmony between fundamental rights and the directive principles. Now, the harmony between fundamental rights and directive principles is across the Constitution. And there is a body of argument which says that you cannot treat fundamental rights and directive principles in isolated silos. You can't simply say that as far as fundamental rights are political rights and as far as directive principles are socio-economic rights, because social content is implicit also in fundamental rights. And all the rights, whether it's dealing with untouchability, whether it's dealing with freedom of conscience, whether it's dealing with cultural, educational rights, they are not rights of an individual. They are rights having a social content, and because they were rights having social content, they are dealing with this particular aspect too. So what these judgments said, Justice Bhagwati dissenting, what these judgments actually said was that you cannot give priority to directive principles over fundamental rights, which is what was the occasion for Justice Bhagwati's dissent, where 31C is concerned, because the latter part made directive principles prevail over fundamental rights. Of course, his reasoning was that in substance you are basically doing what is the mandate of Part 4, and therefore you cannot possibly say that the basic structure is altered, because the Constitution itself contemplates factoring those rights into account. But where the error came, the error was that by means of a legislative fiat to constitutional amendment, the possibility of examining whether the measure did warrant priority of directive principles of fundamental rights was not available. So that is where this particular error cropped in. But nevertheless, these judgments show that as far as the harmony is concerned, fundamental rights and directive principles go together. Thereafter came these a host of other judgments, but I will not deal, because we're running out of time. I will not deal with all. two are important, but I'll deal basically with Coelho and then come to the judge's case of 2016. Now, the occasion of Coelho was the 29th Amendment. 29th Amendment got the 9th schedule. Now, the question of 9th schedule was, how has 31B been upheld? Has 31B been upheld unconditionally or has it been upheld conditionally? There was a dispute. Justice Bhagwati and Vaman Rao, actually, I think, in the judgment which he gave that, and actually said that it was held valid. And to the extent Justice Riyad said it is unconditionally valid is not correct. That's not strictly speaking relevant. But the issue was, what do you deal with laws which are put in the 9th schedule? Now, those laws that put in the 9th schedule are through the medium of 31B. 31B is the Constitution. The amendment is to 368. If amendment to 368 is limited, can you, under the guise of 31B, immune from scrutiny all laws whatsoever? What Coelho says is, it applied basically the test which was already prevalent, that is in Keshavan Bharati's case, but nevertheless explained it differently, borrowing it also from Nagaraj. And what it basically said is that you will first see, without shunning it of all legalese, you will first look at the amendment bringing the laws, see whether the laws are violating fundamental rights. And once you see the laws if you see the laws are violating fundamental rights, you deal with the impact of those laws on the basic structure for the purpose of judging whether in fact the amendment is valid at all or not. So that is the impact and effect and the sense of rights test. The sense of rights and impact and effect test. So that you see, so the fundamental rights by themselves may not necessarily violate, but insofar as the effect on the basic structure is concerned, in the facts of that case it can. And here the test is what Justice Chandrachud had said in Indira Nehru Gandhi. On each, you pick up the provision, you see the purpose of the provision, you see the place of the provision in the entire scheme, and you see the consequences of the deletion of that particular provision on the basic structure. This is basically how you decide if the basic structure is violated at all or not. So applying these tests, following Keshavan Bharati, what Coelho did is, because it came after a fair period of time, gave Keshavan Bharati a surer foundation. Surer foundation and all this dispute which you now have, whether Keshavan Bharati is here to stay at all or not, or what are the principles on which Keshavan Bharati is applied? Is something brooding omnipresence in the sky, or is there certain legal foundation for it? That is all answered by Coelho. So it rests on very sound legal foundations. And then came finally the judgment in the NJAC case. And the NJAC case is important. Why? All of you must read Chalameshwar in this particular judgment, because as far as the other judges are concerned, they have picked up different parts of the fundamental rights judgment. But what Justice Chalameshwar has done is worthy of reading, because we have a broad concept of basic structure. We talk about independence of judiciary, generally, independence of judiciary. And he says, see, independence of judiciary is violated. Now, what he said was that the question of independence has to be seen in the context of balance of power. That is, you have to see whether the method which is there brings in what the Constitution envisages are the stakeholders involved in the process. And as long as the stakeholders involved in the process in their respective roles are present, mainly because a method is devised different from what was there earlier, will not necessarily mean it's violating the basic structure. So, contrasting what Justice Chalameshwar says with what the rest of the judges say, you can actually put into focus and understand what the issue of basic structure actually is. And while on this, I will also recommend to you in Minerva, the reasoning of stare decisis. Whether stare decisis can at all be used for the purposes or dealing with constitutional amendments, because it should be a subject matter or a separate lecture altogether. But these are aspects which you must read, because when you are dealing with the Constitution, you have to have a broad idea of how the Constitution is to be read, because as I said in the beginning, being fundamental and organic and basically the root of public law, our entire constitutional jurisprudence depends upon how fine our understanding is. And here, all the concepts which have been covered over time, from 1951 onwards till date becomes very relevant for the purposes of our becoming aware of everything relevant to a very important field of constitutional jurisprudence which will underpin public law in this country. So, as far as topic is concerned, I would say, don't read the judgments alone. Do read articles and read as many articles as you can, specifically the two I just said. And Justice Subbarao also has written an article in SCC. It will be in SCC online. It is worth reading because we are constantly being fed with certain ideas about basic structure. It's not wrong. I personally feel basic structure is important. Indira Nehru Gandhi proved it. Consequences cannot be ignored altogether, and check has to be there. While check has to be there, the check cannot be in the air. The check has to be rooted in the Constitution. So it is our reading of the Constitution which is going to decide what the basic structure is. We cannot be loose about our submission and say, look at the preamble, because the preamble is too broad and vague for the purpose of this particular purpose. So we have to still understand what the Constitution says. So when you are dealing with this, read Sirvai. Sirvai has a whole section dealing with Keshav and Bharati. Read Bakshi. Read Tripathi on this. The book which I mentioned about constitutional and basic structure is a compelling read where this aspect is concerned, and approach it with an open mind, because there is much to be said for both views. It's not as if one view has got a sanctity which the other lacks, and as far as the view which is different from the basic structure is in fact also rooted in the Constitution, and even that view acknowledges that you cannot undo the Constitution, and therefore you can read the view not conforming to Chief Justice Sikri to say that even the 6 judges who did not do it actually admitted that certain principles are inviolable. That's all. Thank you.